everybody for coming today. This is our 6th annual conference and we're very excited for the day we have ahead together. This panel is going to talk about sanctions, and together with the travel ban, sanctions has been a new front that has been challenging our community and putting pressure on our community. And that's why at the IABA, about a year ago in last year's conference, where we had the same group of sanction specialists with us, we thought we should start a sanction task force, a subcommittee or committee of the IABA that can sit down and talk about what do these sanctions do to us and where do we need to maybe take some action. And one of the first things that came to our mind is education is a big part of this. The sanction laws are complex, and it's very important for us to know how to navigate this area. And that's why we put together the sanctions booklet. You should all have received one by now. And the idea here was to ask all the questions that could come to the mind of a number of people together and have the experts in the field really try to put some answers to those questions. So we're very thankful of the people on this panel that joined us on this project and kind of gathered all this information. So with that, I'm going to ask each of our panelists to introduce themselves, and we'll have conversations about this new and continuing developed field, sanctions and OFAC compliance.
Hi everyone, I'm Eric Ferrari. When I woke up this morning, I was principal of Ferrari and Associates, but as you'll see in the program guide, I am now partner at the Casaroni Law Group. So I got some explaining to do to my associates on Monday, but I'm excited for the opportunity. And in all seriousness, I wanted to thank Ramin and IABA and of course my esteemed panelists for doing this. We are all sanctions practitioners. I have a slight bent towards the enforcement side of things, but we do quite a bit of compliance work as well, and have been for some years, particularly with respect to the Iran sanctions program. So excited to be here, and thanks to all you guys for attending.
Good morning, everyone. My name is Mehrnoush Yazdanyar, and I've been doing sanctions work. I don't know, I was talking to Eric, I was like, the first time I think we did something like this was 10 years ago, like a panel about, and time flies, but I want to really express my gratitude to the IABA for having programs like this, for working on, I'm sure, the sanctions booklet that will be talked about later, because the sanctions are something that really do impact our community, regardless of what your background is, your political beliefs, your socioeconomic background, your anything having to do with Iran or the United States. If you have ties to Iran, this impacts you. So it's very important to educate yourself. I'm grateful for the invitation to be here, and I'm also grateful for forums like this where we can talk about the problems that we face. So thank you.
Good morning. My name is Zahir Falahi. I'm an attorney and a certified public accountant. I do primarily tax law and OFAC, just Iran only. Anything other than Iran, if there's the other 14, 15 countries, I refer them to Eric Ferrari.
Thank you.
And thank you.
So many of us are familiar with sanction law, but Eric, could you give us an overview of how sanctions work?
How much time do we have?
Let me get my notes.
Because this is
4
usually...
minutes.
Okay, 4 minutes, great. So I'm going to talk fast. So first of all, just a little bit of primer on sanctions. When we're talking about sanctions, we're talking about those authorities administered by the United States Department of the Treasury's Office of Foreign Assets Control. It's a little group of folks in the Freedmen's Bank building, used to be the Treasury Annex building in Washington. There's about 190 people there that administer 37 different sanctions programs. Those sanctions programs are divided up generally into 2 categories: country-based trade embargoes and targeted sanctions programs. Country-based programs are those that target a particular country, region, or jurisdiction. For example, Iran, the Crimea region of Ukraine, Cuba, Syria, North Korea. They vary from program to program. For Iran, which we'll stick with, considering we are at the Iranian American Bar Association National Conference, We're talking about a virtual ban on all transactions between U.S. persons or with respect to U.S. origin or U.S. situs property with or in connection with Iran. So it doesn't need to just be with the country itself. If a benefit is derived within the country of Iran, it potentially is subject to the prohibitions of what we refer to as the Iranian transactions and sanctions regulations. Those prohibitions include imports and dealings in Iranian origin services and goods, export of U.S. origin goods, exports and re-exports of U.S. origin goods, services, and technologies, prohibited investment in the country, and facilitation, which involves doing anything that allows a foreign person to engage in what would be prohibited activity with Iran, where a U.S. person directly involved. And I'll explain what U.S. person means in a second. The second tranche or category of sanctions are these targeted programs. And really they fall into three categories: primary sanctions, derivative sanctions, and secondary sanctions. When we're talking about primary sanctions, you could be talking about country-based trade embargoes, but when you're talking about it in the targeted blocking sense, it means that someone has engaged in conduct which is identified by executive order, statute, or regulation to be sanctionable. What's the difference between prohibited and sanctionable? Prohibited means it's an actual violation of civil or criminal law to engage in the transaction. Sanctionable means that the conduct could lead to consequences for the party engaged in it. For example, they could be identified on a blacklist, which we refer to as the specially designated nationals and blocked persons list, and there could be no dealings between U.S. persons and parties on those lists. They could be subject to an immigration visa ban. They could be subject to prohibitions on receiving loans or credits from the Export-Import Bank, and there's a variety of different menu-based sanctions that fall in there. The primary sanctions are those parties who are engaged in the conduct that is identified. So, for example, provision of support, I'm sorry, not provision of support, but engagement in terrorism, proliferation of weapons of mass destruction, narcotics trafficking, so on and so forth. Derivative sanctions are those sanctions imposed on persons which are providing support and service, acting for or on behalf of, or otherwise materially assisting the persons engaged in the primary sanctionable conduct. So, for example, if you are providing financial support to a money launderer of a drug cartel who's identified by OFAC, then you yourself could be designated under a derivative sanction program. And then there's secondary sanctions. Secondary sanctions work along the same lines, except there's no materiality between the conduct and the designation. So, for example, if you're just dealing in a particular sector of the Iranian economy, for example, now construction is one of those, you could be sanctioned just for your dealing in that sector. So I know that was a lot and I was talking fast, but that's the overview on that. Just one note on jurisdiction, and I'll turn it back to Rami. Jurisdiction is over U.S. persons, U.S. origin goods. U.S. persons are defined as citizens and permanent legal residents wherever located. So if you're in Japan trying to do business with Iran, but you're a U.S. citizen, you are prohibited from doing that. Also, those individuals physically present in the United States. So if someone comes over from Iran, let's say on a student visa, but they're engaged in transactions with Iran, let's say they have a bank account and they're causing funds to be placed into that bank account in Iran, that is actually a violation of 56207 for prohibited investment. U.S. origin goods as well. So if something's manufactured in the U.S., if something is created by a U.S. company, if something is created in another country and then comes to the U.S. and then is re-exported, all of those are U.S. origin goods, and those provide jurisdiction to OFAC to impose a civil penalty or to the Department of Justice to bring a criminal enforcement action. One last note on jurisdiction: the Iran program, like the Cuba program, is a little bit different than some of the other programs insofar as they also capture the conduct of U.S.-owned or controlled foreign entities. So because of a provision in the Threat Reduction and Syria Human Rights Act of 2012, Congress expanded the jurisdiction so that OFAC could prescribe the conduct of U.S.-owned or controlled foreign entities. What is a U.S.-owned or controlled foreign entity? That is one in which the equity is owned 50% or more by U.S. persons, where the majority of the board of directors is comprised of U.S. persons, or where a U.S. person controls the actions, policies, and personnel decisions of the foreign entity. So that last one is really vague, and OFAC has offered no guidance on it. But essentially what Congress tried to do and what OFAC has aggressively enforced is a virtual ban on dealings with Iran wherever a U.S. person is involved. That's the takeaway.
Isn't that exciting?
There's a couple of people still awake, so that's good.
As you guys know, the story of sanctions and JCPOA has been moving and different things have been happening. And so, Mehnush, what has changed since last year when we were speaking about this?
So when we talk about Iran sanctions, it's really important to take into consideration that there are a lot of moving parts and variables in this grand equation, and OFAC and the law is just one variable. I mean, it's an important one. Obviously, you have to know the law. But there's this whole other side that we're dealing with. This isn't a situation where we have the United States government administering and enforcing a set of regulations that is done within the United States, that is under laws that are very clear. This is something that involves banks in the United States. This is something that involved third country banks. It involves Iran, so Iran has its own set of regulations that change when it comes to money transmittal issues. This involves currency exchange brokers, people who are actually sending the funds, and the regulations in Iran that impact that, how third country banks move along with that. So often what happens is that there aren't major changes in the actual laws that impact us. And I'm speaking more for the personal remittances side or the personal assets. I mean, obviously, as Eric was alluding to it, we have changes that we've seen, addition of specially designated nationals, especially in this administration, left and right. Every day we hear something new about the sanctions. But if you look at the actual regulations that impact individuals who want to transfer assets from Iran to the United States, even from Trump's administration, it hasn't changed that much. Even with coming out of the nuclear deal, it didn't change that much because primarily that dealt with secondary sanctions that dealt with what other countries could do vis-a-vis Iran. One major change that did happen, and I couldn't even remember last year when the conference was, so I'm going to cover this, is that we have had a general license in place, and a general license is something that the government of the United States, OFAC, says that certain conduct is not against sanction policy. It's actually to the benefit of the United States, so we're just going to make it legal for all U.S. persons as described by Eric. So we had a general license that permitted people to bring non-commercial personal remittances to the United States, gift or an inheritance from a family member in Iran. We had a general license in place that permitted the sale of real property in Iran, property that had been acquired by someone prior to becoming a U.S. person or inherited after. In November of last year, we saw an addition of a general license that permitted the sale of personal assets as well. So prior to that, if you wanted to sell your house that you inherited from your grandmother in Iran, that was legal. But then if that house came along with, furniture, if it came along with antiques, and it came along with whatever else, you needed to apply for a specific license from the government that would permit you to do that. So that was an important addition. Now, in actuality, with all of the tension that's happening and all the movement on the Iran and U.S. side, even though there haven't been any major changes in the regulations, we have seen changes in the other variables that we've been talking about. U.S. banks have become very, very diligent in scrutinizing transactions that they flag or feel like have anything to do with Iran. Why? Because in theory, it's so great. The sanctions policy is aimed at the government of Iran and not at the people of Iran, certainly not at U.S. persons. So they have these general licenses that are in place to make our lives easier. But when two countries have absolutely no relationship and there is no direct banking method or mechanism through which you can transparently send assets across, that's problematic. Because even if you have a transaction that's permitted under the law, you can't go to Parsian Bank in Iran and send it directly to Bank of America. You have to go through a currency exchange broker. How does that work? Well, I'm sure we'll cover that later. And I know I don't have much time. You should just nudge me. One of you two just stop. But
That is good.
sorry, I get very passionate about sanctions, I know. But
It's just exciting.
it is. I mean, it's riveting. I can't think of anything else I would want to do on a Saturday morning.
Yeah.
But well, I'm happy, but I really like that. But anyway, so on the U.S. side, on the banking side, they have really begun scrutinizing these transactions. So reporting them and making those transactions transparent is important. One of the most important changes that's occurred is on the Iranian side, currency exchange brokers are more heavily regulated or in a lot of times not even permitted. So what we're hearing on this side is that, oh, we can't find a broker to send the money, or it's illegal for a broker to send the money. So brokers send money in smaller increments, whereas prior they would send it in $300,000 chunks that we would report once to the bank here. Now they're sending it in $20,000, but $50,000 from random places. Worst case scenarios is that we're seeing that because of this regulation, the difficulty of currency exchange brokers on the Iran side to move money, they're starting to do more deposits from inside the United States into your account, which is a huge no-no under any circumstance or condition. And in addition to that, I've noticed, and I'm actually curious because I hadn't had a chance to talk to Eric or Zahir prior, I've noticed some incredible delays on whenever I request either guidance from OFAC or license applications. In some instances, we'll request guidance and we'll hear back within a week. In some instances, it's been 7-8 months. We've had licenses that prior we would get a response in 6-7 months. It's now been over a year in some cases. So on the OFAC side, on the administration side, we're also seeing some delays. So it's just important to remember that even if there aren't changes in the law, in order to help your clients, you need to understand all of these different variables, all of these different moving parts, and if there's an internal policy change in the banking and how they regulate these transactions, or on the Iran side in those laws, or how a broker actually moves money, you need to be on top of that. Otherwise, you're not going to be able to do your job effectively.
Yeah, and another problem is also there's things that quote unquote are legal, but still in practice there's a lot of limitations. So Zarjan, can you talk about whether general licenses or specific licenses that might be there for people to transact but are facing various types of difficulties in doing so?
Yes, first, as far as delinquency, Maruchan, yes, that's how they are. They're extremely delinquent. Sometimes they send you, they respond within a month or so. I have a case since December 8th of last year. They've called a few times, apologized, they are late, and they're going to get back to me, but, it's still there. And I know the reason, of course. As far as the problem with the people who actually are authorized, whether by general license or a specific license, the major issue as the obstacle is transfer money, actual transfer money. Having said that, I have clients that they bring money almost weekly, a couple of times a week. I handle a lot of people, assist people. It has become more difficult, and it is not just OFAC. Basically, it's a Bank Secrecy Act. There's a law was in fact enacted in 1970. It's called Anti-Money Laundering. Bank Secrecy Act, basically the purpose is to combat terrorism financing, anti-money laundering, tax evasion, and all that stuff. There are about 4 sections of Treasury that I deal with a lot. One is called FinCEN, Financial Crimes Enforcement Network. That's the one that's specifically after enactment, maybe 1973 or so. Since then, they've been in charge of handling, basically implementing the Bank Secrecy Act. And once they find irregularities, they refer to the Department of Justice or U.S. attorneys, depending on the case. The other one is Criminal Investigation Division of the IRS. Last year, probably I filed 160 or so reports with the FinCEN, Financial Crimes Enforcement Network. I deal with them a lot. Criminal Investigation Division, that's specifically for that's part of the IRS. That's a very large organization, and a lot of undisclosed foreign bank accounts. Whenever we go for amnesty program, we go through criminal investigation, get clearance with them. I deal with them maybe 2 or 3 times a week. I deal with them a lot. And anytime there is an indication or evidence or potential occurrence of any kind of crime or suspicious activity, any of those organizations, they could get involved. And the primary business or entity section which actually may generate that kind of report is the bank, private banks. When the money comes to the U.S., generally they go through a Federal Reserve Bank of either New York, if it's come from European side, or coming from Asian side that could go through San Francisco. And before they release the money, because they know, the banks know, the money has been reported to 8 different organizations. And so they do due diligence work. Major changes have happened since last time we spoke. Almost every other week, every 3 weeks or so, Financial Crimes Enforcement Network has issued something warning all financial institutions dealing with Iranian banks, unfortunately. Last one was less than 2 weeks ago. October 25th, they issued an announcement, and they they determined that that's number one money launderer, whether it's true or not. But anyway, they've scared the people. You know, the new human, what is the term actually? It's called humanitarian trade mechanism that OFAC just announced. Along with that goes another really hard due diligence, or very heightened, which is called the final rule. They just called it November 4th, actually, a couple of days ago. Based on that, they get some kind of clearance with OFAC for handling those programs. They want to make sure that money is spent specifically for those purposes. So because of that, transfer money has become extremely difficult. And again, the concern is that the banks do not want to get involved, kind of like problems that Deutsche Bank had in the last 3-4 years, several years. They had to pay hundreds of millions of dollars in penalties. So that's the major challenge. But again, I don't want to scare anybody. Basically, money transfer is taking place almost daily and weekly.
Awesome, thank you, Zahir. So Eric, how does the enforcement side of this happen, whether civilly or criminally? What typically happens once there's an issue?
Okay. No worries. So I'm going to focus on those two areas, but I also want to touch on the sanctionable side of enforcement as well. I'm actually getting placed on the list and named as a specially designated global terrorist because there was a case last year that was really, really interesting and involved something that'll be relevant to the next panel, which is humanitarian trade. Bank Parsion was designated last year in October 2018 as a specially designated global terrorist. And the reason for that was because, try to follow me on this, they had investments which were purchased on the Tehran stock exchange by Andeshe Mehvaran Investment Company, which had investments from Iran Tractor Manufacturing Company, which had investments to another company, which had a customer from another company, which had investments from Mer Eqtisad Investment Company, which was owned by Mer Eqtisad Bank, where the Bonyad Basij held accounts at, and Bonyad Basij provides support to the IRGC Quds Force, which is designated as a global terrorist. So therefore, Parsion Bank, through those 8 degrees of separation, one more than we'll get you to Kevin Bacon, was designated as a specially designated global terrorist. So the reason I tell you this, and this is maybe a little bit biased and self-serving because I represent a lot of parties on the list, is just because you hear someone is a global terrorist or they're a narcotics trafficking kingpin, that's how OFAC reaches those decisions, through those levels of derivation. I'll get off my high horse on that, and we'll talk about civil and criminal enforcement. So civil enforcement is judged on a strict liability basis. If you violated the regulations, you violated the regulations. For most prohibitions, although 56204 has a knowledge requirement in there or a reason to know, there are no knowledge requirements. There's no necessity for them to show you knew the law. The actual legal standards is, does OFAC have a reasonable cause to believe that you engaged in the violation? The judicial review standard is whether or not their action was arbitrary and capricious, which means a court who would be reviewing a civil enforcement decision would not substitute its judgment as to the facts, but just see if OFAC's decision, or the path to OFAC's decision, could be reasonably discerned. In making those determinations, the courts provide extreme deference to OFAC since the laws it administers sit at the intersection of administrative law, national security, and foreign policy. And there's no evidentiary standard. So I could literally walk into OFAC and be like, listen, I'm friends with Marnoush, but she is selling AK-47s to Iran.
Something I would do.
Something I would do. Hey, business is business. And OFAC could use my statement as an anonymous source in an enforcement investigation to impose a penalty. The way they gather the information is through what they call 602s, or administrative subpoenas, meaning they send you a letter. It says, hi, we're the United States Department of the Treasury's Office of Foreign Assets Control. We have some questions. Looks pretty innocuous on its face. That's them gathering information to potentially penalize you or engage in some sort of enforcement action against you. They also receive a lot of information from banks. So sometimes if a wire transfer gets held up, the bank might ask questions. A lot of that information that is being gathered is then being sent either to FinCEN, as Zahir mentioned, or directly to OFAC itself to be used both as for intelligence gathering as well as for enforcement investigations. And they also receive a lot of information from the intelligence community and other law enforcement agencies. Penalties can be pretty severe. The maximum, it just went up again, what's that, 300 something? It's approximately 300,000 per transaction, or twice the value of the transaction, whichever is higher. There's a whole way to calculate that. We don't have time for that today, so I'll move on to the criminal side of things. The difference between a civil OFAC violation and a criminal violation of OFAC administered authorities is willfulness. Okay, that means that you knew you were in breach of a known legal duty. How do they prove that? It's not as much of a bar or a defense as you would think. So I've seen, and I'll just give you two examples. In one case, they proved willfulness by showing that the individual who wanted to send money to Iran walked into a bank, asked to send money to his bank account in Iran. They told him, you can't send money directly to Iran. And so from that point on, that was their evidence of willfulness. So the fact that a bank teller, this was in Chattanooga, Tennessee, said that you can't send money directly to Iran was used as evidence that this individual willfully engaged in a violation of the Iran sanctions program. The second, and I can't talk too much about this, but I've seen it in discovery in a case, was that there was an email to the individual engaged in the prohibited conduct from a friend of theirs who shared a lawyer not to be named's informational packet on U.S. sanctions targeting Iran. So everybody who is in possession of this sanctions booklet at this event, if you do want to engage in violations, I would advise you to throw this in the trash and not keep it anywhere on your person or in your email, because that could potentially demonstrate willfulness of a violation. So here's the other piece of this. What the Department of Justice loves to do is they love to tie the sanctions violations into other violations, so tax evasion, money laundering, and so they might have a harder time to prove the sanctions case, but if they have you on other charges, they can convince you to plead guilty to the sanctions violation as well. It looks like they're doing an awesome job. The Department of Justice puts out a press release. They're like, look, we got this bad guy. He had a bank account in Iran. You know, we stopped that. Great. And they can pat themselves on their back. So that's my very jaded and quick take on the enforcement process. Thank you.
Thank you, Eric. So, Mehnush, you briefly touched on transferring funds from Iran, but maybe if you can expand on that, and also if you can touch on how that would impact the availability of medicine and goods in Iran.
Okay, so money transmittal in Iran, the way that it works is, first you have to make sure that you can bring it over, which we've discussed. If you can receive a gift or an inheritance or what's called a non-commercial personal remittance from Iran, and also proceeds from the sale of real or personal property that you acquired prior to becoming a U.S. person or after as an inheritance. Number one thing is that U.S. persons are not allowed to have bank accounts in Iran. So nowhere should you be saying, yeah, I sold this property and then I opened a bank account, I deposited the funds and I'm sending it over, or your mom or your grandma who is a green card holder did the same. Then what do you do when you have the money in Iran? So you have to give it to a currency exchange broker. How that works is that you give the Iranian currency to the broker and you get what's called arz havalei, money that's going to be sent to you from a third country. Sometimes it comes from inside the United States, and we'll talk about that. The problem is that this conduct is generally licensed. So contrary to what a lot of people that say that they're OFAC practitioners do, is I've heard, they'll just go and apply for a license for something that's generally licensed. What happens is then OFAC gives a letter to you that basically says, kind of in one paragraph, describes what you've applied for a license for, and then ends it with saying, if the conduct that you want to engage in falls within the scope of a generally licensed activity, we will not give any further authorization. Then that person gives that document to the client and says, well, here you go, here's your OFAC. OFAC-esho gereftem barat. And I'm like, dude, OFAC gereftani neist, first of all. Second of all, that is not an OFAC license. That is a correspondence. It's a letter that's returned without any action. It has no legal significance for you. What you need to do is you need to report this activity to the compliance department of your bank, not to your branch. And that's another problem, is that a lot of people go inside the branch and they tell the person, hey, I'm going to bring money from Iran. And really, you're at the mercy of that person that you're speaking to. Does that person know anything about money transmittal issues? Do they know anything about compliance? Do they know anything about how this should be reported? Do they know that they have a specific department within their bank that's literally designated to go through these transactions and make sure that they're legal? Sometimes they do, most often they don't. So they tell you to engage in the transaction, and then what happens? Your money comes and all of your accounts are closed, and then we get these frantic calls, I've been working with this bank for 20 years, I have millions of dollars in this account, I have a business account here, and I have that, and they closed all my accounts. What can you do? And the reality of it is once the bank makes a decision that you're a high-risk account and they close it, it is incredibly difficult to reverse that decision. And that's the best-case scenario for you because nothing was restricted, nothing was blocked, and then you could take your money. So what do? So you're going to receive this money, so you make sure that the sender is the non-US person that's giving the money to the currency exchange broker. You make sure that the currency exchange broker is going to send the funds from a third country bank. A lot of times I get the Sarov is never going to tell me where the money is coming from. They may not tell you exactly where it's coming from, but if you tell them, I'm going to receive money from Iran, and if I check my bank statement, and this is deposited as an internal wire transfer, as a check deposit, as a cashier's check, as an over-the-counter deposit, I'm going to tell my bank, I don't know where this money came from, and then they'll know that that's going to have consequences, and they'll most likely try to send it from a third country bank. The next step is you have to give compliance documents to the OFAC sanctions, global regulations, whatever, every bank's name is different, of your bank, so that they know when this money is coming. This $50,000 from Turkey or somewhere in Emirates or this third country bank account that has nothing to do with your bank account, what the source of money is. Because the reality of the fact is that the banks are put in an unfair position of policing these transactions because OFAC is saying you can engage in this conduct, but there's not giving you a channel through which to do it. And if the banks accept any money that is in violation of the sanctions, they pay the penalties. So if you're here, you're Bank of America, and you have a client that's getting $100,000 from this account and $50,000 from this other account, and then $30,000 from this other account, and then $10,000 from inside the United States, it's like, well, what the heck? I'm going to flag this, I'm going to close it, So you need to report that. And the sad news is, even when you report it, a lot of times, if you're bringing a large sum of money, like it's regarding the sale of real property, and you're one of the lucky ones that can get over, $500,000 for any property in Iran today, that then because of the frequency of these deposits, there's a probability that that account might be closed. I always recommend to clients that maybe, don't bring in money into that same account that you do business with, that all your, or obviously not business with, sorry, in that bank that you have your personal account and your business accounts in, open maybe another a bank account, report everything, and then worst case scenario, if something gets deposited outside of your control, and then they decide to close your bank account, it's not going to affect your entire life. The only other thing I'll say is that I've noticed there's this case, actually it's a bunch of cases, that's coming out of Chicago that's related to money laundering scheme. And what has happened is that a lot of times people receiving money from Iran are the prime victims that can be used for money laundering mechanisms. And in this particular case, what happened is we had a group of, and this is the information that was given through FBI in Chicago, is that there was a group of individuals from Pakistan and Turkey that came here in the United States, and they set up these false medical entities, and they were engaging in insurance fraud. And what they would do is they would maximize these insurance claims, they would take the money, they would close this entity, go open another entity. What happened is they had millions and millions of dollars in fraudulent money here in the United States. How did they launder that money? They worked with third country currency exchange brokers, and they said, oh, you want to send your clients money in the United States? Well, we have money, we can be your agent here. So what would happen is, your grandma would go in, give $50,000 to the broker, and then the broker would work with some other currency exchange broker from another country that would then tell these guys, yes, deposit $50,000 into my client's account. You think you're getting your money from your grandma from Iran. These people are depositing $50,000 of this, ill-gotten gain, this fraudulent money into your account, and then they're taking your quote-unquote clean money in wherever that third country broker is, and off they go. Now the FBI is coming and is seizing those accounts and holding the recipient, who is in a way a victim of this scheme, liable for that. So the number one thing you need to tell people, do not accept money from inside the United States. It's incredibly dangerous, and if you do, take the steps to report it to your bank, because at least there's some record of you trying to correct this wrong.
Yeah. So Zahirjan, what about the tax implications? Let's say you jump all these hoops and you are able to bring some funds to the U.S. What happens on your tax planning scheme?
Before I answer the tax question, I just want to add something to what I said earlier. When I deal with the criminal investigation division of the IRS quite a bit with financial crimes enforcement, it doesn't mean my clients are criminal or anything like that by any chance, by any stretch of imagination. In fact, I ran into one of the judges in another bar association who asked me, "Oh, so Mr. Valahi, I heard you handle these undisclosed bank accounts." I said, "Your Honor, before I answer the question, let me submit to you, all of my clients are innocent. They just forgot to report." And she said, "Oh, yeah, I know that. You don't need to explain that to me." The other thing is the cases that Mehnush was referring to, bank accounts, things like that in Iran. So in addition to the issues that we're talking about, sanctions, violations, and also as a tax attorney and a CPA, I see also there are tax issues involved, foreign tax issues, foreign non-filing of FBARs, report of foreign bank and financial accounts. So there are huge issues on any of the people who have violation of sanctions, specifically people who have bank accounts in Iran. On top of a lot of sanctions, we have lots of violation of lots of taxes also. Now, Rami, with respect to your question, regardless of what kind of license we have to cause a transaction in Iran, they do not have any effect on the taxation of it. Tax laws are completely different. They apply to all transactions, generally all transactions taken place in Iran or with respect to Iran. Very briefly, sometimes the income is just a regular income. For instance, somebody has a violation, as Mehnush was alluding to, would be like rental property, for instance. Having a rental property in Iran is violation of lots of sanctions. Then again, with tax aspect of it, we have regular income. Sometimes we go back to 6 years or 8 years, depending on the circumstances. But the main determinant factor actually is not the license controlling that transaction, it's actually the length of time the property held. So generally we're talking about capital gains taxes. And the property, two categories of the properties that they are exempt from lots of sanctions, where our Mehnush alluded to them. One is property acquired prior to becoming a U.S. person. Generally, you don't need to get a license. There's a section 543 covers that. It's just some kind of general license, but specifically for property acquired prior to becoming a U.S. person or property acquired by inheritance in Iran. Those two are, most of the time, that's a lot of sections, clients that we deal with are those two. Although those are exempt from lots of sanctions, general license covers those things. In fact, they have sometimes the largest tax consequences. And the reason for that is the length of time, because I've been here for the last 42 years. A lot of people have been here that long, maybe longer, even 20 years, 30 years. We handle a lot of cases. So depending on when the property was transferred to a person, that may be the basis for tax calculation. So if you're talking about, Mr. Valahi, this is the property, somebody told me this is the property, since I had it before I came to the US, there is no taxation. I said, no. No, the attorney probably said that it's exempt from lots of sanctions. But what is the difference? But I don't want to pay taxes, though. I said that nobody does. But I'll just tell you what the law is. So, and the reason for that huge tax consequence for that property is that because this property was owned 44 years ago, you got it, you bought, either it was a gift or not. If I'm going to talk about the gift a little more, but the property, suppose you bought it. Then it had very little basis. And the property, although property is appreciated quite a bit, and the fluctuation rate has taken some of the, the gains away, but still, a lot of these people, they have tax consequences. The basis is very small. The other item would be inherited property. Again, inherited property exempt from all of the sanctions, and also generally it's tax-free. It is free if you sell the property right then or within a reasonable time of getting the property. It doesn't mean that, I said, Mr. Client, how long have you had the property? And the scratches it said, my dad passed away 3 years before the revolution. I said, so it's about 40-some years, 43 years or so. Wow, you know what? I'm afraid you're going to have tax consequences. No, but they told me. You told me on the radio. You told us on the radio that inherited property is exempt. I said it's exempt if you sell it then. However, some of these properties have tax planning kind of, systems in it. I'm going to allude just two of those. One is just a primary residence type. This applies to people who just came, recently came, newly arrived people. There's a law, so Section 121, primary residence. Joint filers.
Sorry, John. I'm sorry about it. We're out of time, and I want one quick question.
Okay, sure.
With one sentence, if that's okay, everybody. So we're facing with all these challenges. Is there anything the Iranian American community can do and the organizations to try to make the situation a little bit better?
That question is to me.
Yeah. For the panel, just really brief, 1 or 2 sentences.
No problem. I guess there would be from up, down, really. We're talking about the administration because the pressure that's put on the banks because of the, excessive due diligence is because the government, one government is fighting another and has put a lot of pressure and wants to, has already cut off the other country from the banking system of the world. So that's the thing that I guess that would be at a very high level is up, down. That's my comment.
It's like impossible for me to answer this question, but I'm just going to limit it to attorneys since this is a legal conference. And I think the number one thing we can do is educate the community about the regulations and educate lawmakers about how they're impacting us. But even more important than that, don't give advice about something you don't know. Like, don't. I don't understand. As lawyers, why can't we just say, you know what, I don't do that, or I don't know that, and here's someone who can help you, because these laws are ambiguous, they're changing. I mean, we've been dealing with them for 10 years, and I still reach out to my colleagues and get their opinions and advice and still ask OFAC for guidance. So please don't give legal advice or any kind of advice about something you don't know, and be honest about it with yourself and with others. I'm serious.
So I think what's most important from the perspective of trying to get some change through sorry, I'm having a little bit of allergies. I think I'm developing allergies to sanctions, which is it's going to be bad for me personally, but we should be able to make it through this. I should retire. You're right. Communicate the problems the community is having to the people who can issue guidance, who can issue regulations to assuage that. So I can tell you when Marnoush and I first started doing sanctions work, anytime someone wanted to sell a piece of real property in Iran, they needed to get a license. When OFAC started getting a lot of licenses requests, when they started getting a lot of complaints from the community, how burdensome it was, because at the time, the price of real estate was dropping, and the value of the rial was dropping dramatically, and there was an economic consequence, because OFAC had the same delays back in 2010 and 2011 that they have now, maybe not as bad. OFAC issued a general authorization for you to go ahead and sell the properties. So communication with the agency is important. Remember who you're dealing with, though, now in 2019 and 2020, and hopefully not past 2020, but this administration is not one that you can pull the heartstrings on. You have to make the economic case, because if you're pitching stuff to OFAC, it's going to go to the State Department. The State Department is going to review it, and unfortunately, the State Department reviews things from what makes political sense and not necessarily, humanitarian or humane sense. So I think a coordinated effort amongst the Iranian American organizations to gather stories, and I know a lot of this is underway or has already happened, to present that information to policymakers, so at least you can get these little wins like these general licenses, like these guidance documents from OFAC.
With that, we'll transition into the humanitarian impact panel.